Straight ahead on Law&Crime Daily. Game of Thrones actress Esme Bianco sues singer Marilyn Manson for alleged sexual assault. And how much time should Derek Chauvin spend in prison for the murder of George Floyd? Why prosecutors are seeking a higher sentence and the defense argument for a lighter term. Plus, 3 Colorado police officers resign after video shows the forceful arrest of an elderly woman with dementia and the officers later laughing about it. And a surviving victim takes a stand in the Wisconsin trial of a man accused of shooting his ex-girlfriend, her family friend, and killing her father.
I thought I was gone.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmire. Co-host Terri Austin is on assignment covering the Wisconsin trial of Joshua Aide. We begin in Colorado, where 3 police officers have resigned after video released by the attorneys for an elderly woman with dementia shows her forceful arrest. Attorneys for Karen Garner say she was walking home in June 2020 when she was arrested for attempting to steal $14 worth of items from Walmart.
Why are you fighting with me? And why are you trying to slip the cuffs off?
I'm going home.
Body cam video shows Loveland police officer Austin Hopp making contact with Garner. Garner can be heard saying, "I'm going home." Hopp pins her arm behind her back and then places her in handcuffs.
I'm going home.
No, you're not. All right, stand up.
I'm going home.
All right, stand up.
I'm going home.
After her arrest, Hopp, along with Officer Daria Jalali and Community Service Officer Tyler Blackett, can be seen on surveillance video rewatching the arrest.
I had a police car on the back there. And I was like, "Don't play." I was pushing her. I was like,
The videos were released by an attorney for Garner who says the 73-year-old woman suffers from dementia. She's now suing the department in federal court for forcibly arresting and injuring an elderly woman. According to the lawsuit, Garner suffered a broken humerus, dislocated shoulder, and sprained wrists. The federal suit also says she did not receive medical care for 6 hours. Now, the police chief says all 3 officers are no longer employed by the department. A spokesperson for the department confirms the officers resigned on Friday. Joining us today is civil rights attorney Katie Smith and co-founder and executive director of Partners for Justice, Emily Galvan-Almanza. Emily, it's not just that they hurt Garner, but how they joked about it afterwards. Do you think this case could lead to a review of the entire department?
I think it should. First of all, my compliments to whatever lawyer thought of requesting that footage of the officers back at the station reviewing this footage, because I think so often we are distracted by the horrible, horrible videos that we see of the arrest itself, that we forget to think about what happens afterwards, which could really be revelatory about the culture of this department, the training of this department. Fundamentally, though, the mechanisms instilled in police officers, given to police officers, are the mechanisms of violence. So yes, the dehumanization of this person is a cultural problem, but will, more training and cultural assessments and some sort of energetic workshop fix this? No, it won't. They left a woman with a dislocated shoulder and broken humerus for 6 hours without medical treatment. You can't train someone not to do that. You need a different type of professional who is not steeped in a culture of violence and the tools of violence in order to diminish harm.
Agreed. Katie, taking that, what kind of claims could Garner argue against the former officers and the entire police department?
Brian, the best claims, I believe, are associated with the use of force and the denial of access to medical treatment. So we're looking at excessive force, assault and battery, deliberate indifference to medical treatment. Those are usually both federal and also state law claims. The weaker claims are those for false arrest, because it appears there's no dispute that there was a report that she had allegedly stolen something from a Walmart. Now, whether or not that is true, officers are allowed to arrest people when there is probable cause. And in most states, one person making an allegation of theft, for example, would be enough for the officers to make an arrest. So I believe more of the force-related claims are the best.
Makes sense. Thank you both. Now to California, where newly released body cam video shows officers holding a man face down for 5 minutes before he lost consciousness and died. Alameda police officers approached 26-year-old Mario Gonzalez on April 19th. Two callers reported Gonzalez as suspicious to 911. The police department says the officers attempted to detain Gonzalez and a physical altercation ensued. The officers attempted to place his hands behind his back and he suffered a medical emergency. Gonzalez's family says he was healthy and had no known medical conditions. An autopsy is pending.
What do you have?
Sorry, no, it's not that. Okay. No,
All right, yeah.
it wasn't that. Hey, no. Stop. No. Hey.
Mario, just please stop fighting us.
It's all right.
We have no weight on his chest.
You go around there.
No weight.
He's going on sponsor.
Now, there's some similarities between Mario Gonzalez and what happened to George Floyd, and ironically enough, Gonzalez died the day before Derek Chauvin's conviction. Katie, what was your reaction to the case, and how does the suit against the officers look in this situation?
Well, Brian, it does bear the striking similarities to the Chauvin trial. And again, I think it's going to bear down to very similar questions. One, causation. Who actually caused the death of this man? And number two, whether the force used was excessive. So, of course, if it is indeed true that there was a medical emergency that was not caused by the officers, then obviously we have a more difficult path to recovery against the officers. But logically speaking, when you have a prolonged interaction with the police, there is usually some causation there between the force and the death. So much, as we've seen in the Chauvin trial, really hinges on the medical examiner's findings and the cause of death.
Now, Emily, we're still waiting on that cause of death in the medical examiner report, but what could accountability look like in a case like this?
So there's accountability for the officers that we have to think about in a separate bucket from the right answer for the community. I'm a lawyer. I have to be licensed and I have to not do a bad job and cause harm, or I lose my license and I don't get to be a lawyer anymore. I think that officers who do harm to community members shouldn't get to be police officers anymore. All too often, accountability looks like nothing, or like officers getting to quit their job in one county and go work in the next county over. And certainly there's no form of accountability that's been strong enough to change the level of police violence that we're seeing. But I think a better question here is, what does the right solution look like? You know, Alameda is right next to the city of Oakland, where they've got the new macro program allowing people to call 911 and ask for a mental health response instead of a police response. If you listen to the mental health call on this case, people were calling saying, hey, there's a gentleman here. He seems like he might be having a mental health crisis. Could we get a little help? They were not asking for a violent police response. I think the more we utilize programs like macro, like Cahoots in Eugene, Oregon, like the STAR program in Denver. There's actually legislation pending right now in state legislature in California for a 988 number that would let people specifically call. I mean, that's the better answer to this problem.
Great call. Thank you both for that input. Still ahead on Law and Crime Daily, one alternative metal star may need his own personal Jesus after another woman accused him of sexual assault. But first, Derek Chauvin's sentencing date is getting closer. So how long could the former police officer be behind bars? The legal arguments after this break. Welcome back. Former Minneapolis police officer Derek Chauvin will be sentenced for the murder of George Floyd next month. Angenette Levy shows us why the prosecution wants a harsher sentence, while Chauvin's team says the law doesn't allow for it.
The sentencing of Derek Chauvin is really the last big battle to be fought at the trial court level. And it's no surprise that the prosecution and the defense want different things. In Minnesota, sentences are determined by guidelines that take into account a defendant's criminal history. Chauvin doesn't have a record, so under the guidelines, he would be sentenced to 150 months, which is 12 and a half years. But prosecutors want a sentence that exceeds the guideline. It's called an upward departure. They want possibly as long as 40 years.
The judge has the discretion to depart upward to give a greater sentence, although he does not have to.
Judge Peter Cahill will decide whether aggravating factors existed in this case that would allow for an upward departure. Prosecutors say those factors are George Floyd being particularly vulnerable. They claim that Floyd was treated with particular cruelty and that Chauvin abused his position of authority. The prosecutors go on to say that the crime was committed with 3 or more people and happened in the presence of children. Meanwhile, Chauvin's attorney argues against a greater sentence. He says Floyd was not particularly vulnerable because of his size. Eric Nelson says abuse of a position of authority is not a recognized aggravating factor in Minnesota. He also says the other defendants haven't been convicted, and the state has not proven the 3 other officers intentionally aided Chauvin in a crime. He also notes that children walking by and stopping to witness the arrest is not sufficient grounds for an upward departure.
Not only would the conviction itself be reviewed by a court of appeals, but if Cahill does depart upward and give a greater sentence, that would also be an issue on appeal.
Derek Chauvin is scheduled to be sentenced on June 25th. For Law&Crime Daily, I'm Angenette Levy.
Thanks, Angenette. Back with us as co-founder for Partners for Justice, Emily Galvan-Almanza, and civil rights attorney Katie Smith. Emily, former Minneapolis police officer Mohammed Noor got 12 and a half years for third-degree murder. If that's the benchmark, how much should Chauvin be getting?
So I think when I think about the factors that we're hearing here, I believe there's reasonable grounds to agree with all of the factors listed by the prosecution. George Floyd was treated with particular cruelty. He was particularly vulnerable. I actually think that that definition is broader because most people at the hands of violent armed police officers are especially vulnerable. That being said, I also don't believe that piling on more years in prison solves anything. I believe in equal justice. And I think that if a Black police officer were to receive dramatically more years than a white police officer charged with a similar thing under similar circumstances, that would evince the racism, the structural racism of this system. That being said, think of who you were 12 years ago. 12 years is a long sentence. I don't know that piling on more years on top of that will bring any form of justice because George Floyd cannot get his life back. And to me, that would be the only just outcome. So what we're talking about here is accountability. Accountability for Derek Chauvin cannot be achieved through a term of prison years. Accountability has to be systemic, and it has to be a transformation of the way Americans are subjected to our structures of public safety. So I'm not going to answer the sentencing question, I think, in a very direct way, but
All right.
I don't think piling on more years fixes policing.
Fair enough. I'll come to Katie then. How do you think the judge will rule based on the arguments for a higher sentence of greater than 150 months?
Man, it's a tough question, right? And I want to go around the edges of it myself with this because I definitely believe that the aggravating upward departures are essentially met in all cases, especially with respect to particular cruelty and abuse of authority. I believe with the sense of public outcry and also the fact that he was guilty in all charges is going to convince the judge to go a little bit higher than the 12 and a half years. Agreed that more time doesn't necessarily solve all these ills, but I think we should expect something a little higher than the 12 and a half, but not the max.
I can see that as well, maybe somewhere around 30 years. And be sure to tune in to the Law&Crime Network this Friday for an hour-long special on the Derek Chauvin trial hosted by Angenette Levy. Coming up on Law&Crime Daily, a trial 14 months in the making. The major news for the murder trial of Robert Durst ahead of a coronavirus hiatus. Plus, more accusations against Marilyn Manson, why one well-known actress is now suing the singer in federal court. We're back. An actress best known for her role in Game of Thrones is now suing Marilyn Manson, accusing the singer of sexual abuse. Court records show Esmé Bianco says Manson engaged in a year-long campaign of control and abuse against her. According to the complaint, Manson attempted to force her to perform sexual acts, including tying her to a prayer kneeler, beating her with a whip apparently used by Nazis, and electrocuting her. Manson, whose real name is Brian Warner, is denying the allegations through his attorney. The lawsuit, filed in California federal court, also names Manson's talent manager as a co-defendant. Let's bring in civil rights attorney Katie Smith and executive director of Partners for Justice, Emily Galvan-Almanza. Emily, Bianco's Allegations are that Manson basically sexually assaulted and trafficked her. Should we be expecting criminal charges out of this case?
That depends on the decision of the LA County District Attorney and whether a police report is going to be filed by anyone in LA County. I think people forget that the barriers to entry in the criminal legal system are really sometimes very simple procedural barriers. I also don't know what the statute of limitations would be because it varies based on the charge that the district attorney would choose. So there may be other legal barriers to a local case. That being said, it also depends on what evidence comes out on the Manson side in federal court, whether there's enough to inspire the district attorney to move forward or whether these allegations really are provably false.
All right, so we got to see what allegations come out in this federal case maybe. Katie, Manson's lawyer is saying these allegations are provably false. What should we expect next in this case?
Statute of limitations jumps out at me right away. But beyond that, provably false leads me to believe that there's some evidence that, number one, these acts were consensual, or two, that they never happened. Remember, this was a long time ago. We're talking 2009 through 2011. So I expect provably false means we're going to see some actual video footage or text messages, something to rebut these charges.
Yeah, I would see consent being a strong argument here for the defense. By the description of some of the scars, if there are scars there, then that would be hard to show anything but consent, but we'll see how that plays out. When we come back, a woman allegedly shot by her ex-boyfriend and survived takes the stand against him. The testimony you don't want to miss next. Welcome back. The Law&Crime Network is set to be the only camera in the courtroom when the highly anticipated murder trial of Robert Durst resumes later this month. The New York real estate heir is accused of killing his best friend, Susan Berman, in her Los Angeles home in December 2000. Durst's trial had 3 days of openings and 10 witnesses take the stand before COVID-19 postponed the trial on March 12, 2020. The trial judge has repeatedly denied motions by the defense to declare a mistrial over the 14-month-long adjournment. The trial could last up to 6 months. Live gavel-to-gavel coverage begins on May 17th. And the latest trial on the Law&Crime Network is underway. Terri Austin is here to tell us more about the state of Wisconsin versus Joshua Aide.
Aide, a resident of the state, was charged back in August with murdering his ex-girlfriend's father, James Grutnier. Aide is also charged with 2 counts of attempted murder for shooting his ex-girlfriend, Rebecca Borkowski, and family friend John Miller. Police say Aide was dating his girlfriend 5 years before she called it quits in March 2020. According to court records, text messages show his ex wanted him to remove a broken down car from her property.
I was standing next to John. We were looking over the radiators, so if the radiator's in front of me, and I'm looking at the hood, John was standing to my right. And next thing I knew, there was Josh. At first, I just kind of looked at him, and he said, "Hey, boo, what you doing?" And I went to turn. I didn't say anything to him. I just went to turn because I was starting to put tools away. I had a 10mm socket in my hand, and I had turned to the left to put that into the toolbox. There was a laser pointed in the middle of my forehead. And I said, "What the f, Josh?" He had fired, he tried to fire when that laser was on the middle of my forehead, and he missed, and I was able to move just enough. And the next thing I knew is I was falling. I kept saying I was flying. I thought I was gone. I fell, and the next thing I knew, I was on my side. I had woken up and I had seen a police officer next to my dad's Ford Focus, and my eyes shifted to the right, and that's where I saw my dad laying. I remember saying help. I remember my dad wasn't moving. But I had also just woken up or come to, and I was vomiting, and my ear was ringing.
And of course, that was Rebecca Borkowski, the most important witness in this case. She is one of the victims who was shot in the ear. You heard her testify. It was her ex-boyfriend who is on trial, Joshua Aide.
Thanks, Terri. Emily and Katie are here now to break down the Aide trial. Katie, I know that we all swoon for a good opening statement, but what did you think of the defense skipping it in this case?
You're right, Brian. Every time I wait for that opening statement to soak up what exactly the defense is going to do. And I, like you, Brian, tend to swoon over a very solid opening statement. So the fact that one was not made leads me to believe the defense isn't sure what the prosecution's going to put out there, or they don't know what they're going to put out there. It's puzzling, though, in a case of an affirmative defense. If you're going for a reason of insanity or self-defense, you would want to put that out there in an opening statement. So we will see what is yet to come.
Now, Emily, on motion papers, the defense kind of put out there that this is a self-defense case. Do you see that, or is something missing?
Well, in order to prove self-defense, you need some form of evidence, usually in the form of witness testimony saying it was self-defense. Now, let's think about who was there. Two of the people are complainants in this case. One person is deceased. The only person who can really make it a self-defense case is Mr. Aide if he chooses to take the stand. And so I could see a very good argument for his lawyer choosing to reserve their opening, not put their facts on the record because they haven't decided yet whether they're going to be able to poke holes in the prosecution case or whether Mr. Aide himself could have to testify in order to put up some form of defense and create a self-defense case.
So just really quickly, Emily, are you anticipating that Joshua Aide will testify in this case then?
I think it's impossible to anticipate. I don't even think Mr. Aide himself knows that. It's one of the single most high-stakes decisions that a person accused of a crime can have to make. I think it's probably going to be a game-time decision. I assume that his team is prepping him extensively right now in case he needs to testify, but I doubt they've made the call yet.
All right, we'll see how that works out. Thank you both for joining us, and thank you for joining us here at Law&Crime Daily. We'll see you next time as we discuss justice in America.